The wire transfer was dated March 14th. 4:47 in the morning. $22 million, routed through a shell account in the Cayman Islands, directed to a escrow she had opened in my name without my knowledge or consent. I know what time it was. I know what account it came from. I know because tracing money is what I do. I am a forensic accountant. I follow numbers the way a surgeon follows a vein, precisely without emotion, until I find where the bleeding started. The money arrived the same morning my daughters did. She thought she was buying them. She had put a price on my children before they drew their first breath. And she had done it so cleanly, so bureaucratically, so without raising her voice, that she must have believed I would simply accept it. That I would see the number and understand the offer and sign wherever she pointed. She did not know what I do for a living. Or rather, she knew the title. She just didn't understand what it meant. Welcome back to Family Revenge Stories New, the channel where quiet people keep the receipts, and family learns that boundaries have a price. If stories about dignity, documents, and consequences are the kind of thing that reminds you why paper trails matter, drop a comment and subscribe. I'll be here every week. My name is irrelevant to this story. What matters is the credential behind it. I have been a forensic accountant for 11 years. Before that, I spent 4 years studying how money moves, how it gets hidden, how it gets laundered, how it gets dressed up in legitimate paperwork and walked through the front door of someone's life like it belongs there. My firm works with federal investigators, estate attorneys, and private clients who suspect that the numbers they've been shown are not the real numbers. I see the world in ledgers. Every relationship has a balance sheet, what flows in, what flows out, what gets called a gift when it is actually a loan, what gets called a loan when it is actually a leash. I had been doing this professionally for a decade before I realized I had been doing it personally my entire life. Reading the arithmetic of the people around me, calculating what was owed and what was taken, and never once presenting the bill. I married Daniel in October, 5 years before any of this began. He was an architect. He designed buildings that were meant to last, structures with good bones, he always said. He talked about load-bearing walls with the same reverence other people reserve for poetry. I loved that about him. I loved that he understood that some things hold everything else up, and that destroying them is not renovation. It is collapse. His mother's name was Constance. And I want to be precise about Constance because she deserves precision. She was not a cartoon villain. She was a woman who had built a considerable fortune, self-made partially with the kind of inheritance that gives self-made women a significant head start, and who had, somewhere in the decades of accumulating that fortune, come to believe that money was not a means to an end. It was the end. It was the language. It was the only instrument of love she had left. She ran her family the way she ran her business interests, by controlling the terms. Daniel was her only child. He had grown up in a house where affection was distributed on a schedule, and withdrawn at the first sign of ingratitude. He was, by the time I met him, a man who apologized for taking up space in rooms he'd been invited into. It had taken him years of work, real, unglamorous, twice-a-week therapy work, to learn that the contraction he felt whenever his mother called was not love. It was conditioning. I understood Constance from the moment I met her. I had seen her ledger within the first dinner. She gave in quantities designed to create debt. She offered help in ways that required surrender as the co-signature. She said things like, "We're family," with the warmth of someone reading a contract clause aloud. I was, in her calculation, a variable, an unknown quantity, someone who had arrived into her system without her authorization, and who therefore needed to be assigned a value. For 3 years she tolerated me. For 1 year after Daniel and I announced the pregnancy, twins confirmed at 8 weeks, a fact she greeted with a silence so total it had texture, she began to plan. I did not know that yet. I was too busy being pregnant. The girls arrived on March 14th. 6 weeks early. 3 pounds 11 ounces for Nora. 4 pounds 2 ounces for June. The NICU was quiet in the way that places are quiet when everyone inside them is working very hard. Daniel didn't leave for 31 hours. I know because I watch the clock the way I watch everything, in increments, in timestamps, in the specific weight of minutes. Constance arrived on day 2. She stood at the glass in the NICU hallway and looked at her granddaughters with an expression I could not immediately name. I catalogued it and moved on. I had more pressing things to count. Oxygen levels, feeding schedules, the milliliters of milk measured in tiny syringes by nurses who spoke softly and moved with the efficiency of people who understand that stillness costs lives. On the fourth day, Constance asked to speak with me alone. I should note, I was 4 days postpartum. I had not slept in any meaningful sense. My body was in the process of doing several extraordinary and painful things simultaneously. I tell you this not for sympathy. I did not need sympathy then and I do not ask for it now, but because I want you to understand the conditions under which she made her move. She had calculated them too. We sat in a family consultation room down the hall from the NICU. There was a box of tissues on the table. There was a plastic plant in the corner. Constance was wearing pearls. She said, "I want to propose an arrangement that I believe will be best for everyone, including the babies." I said nothing. I have learned that silence pulls confessions out of people the way gravity pulls water downhill. She said she wanted to take primary custody of Nora and June. She said she had the resources to provide for them in ways that Daniel and I could not. She said, "And I want you to hold this sentence," she said. "I have structured a financial instrument that will make this transition comfortable for you." She slid a document across the table. It was a draft agreement. The kind prepared by attorneys who specialize in making obscene things look clinical. $22 million. Structured as a trust disbursement, contingent on the voluntary transfer of parental rights and primary residence of both children to Constance. I picked up the document. I read it. I read it the way I read everything that matters, slowly from the top of the page without moving on until the sentence is complete. Then I set it down. I folded my hands on the table. I said, "I'll need a copy of this." She thought that meant I was considering it. She smiled. Not warmly. The way you smile when you've won a negotiation and you're deciding whether to be gracious about it. I took out my phone. I photographed every page. The draft agreement. The cover letter from her attorney. The wire transfer confirmation she had included. She had already sent the $22 million. Assuming I would cash it before the ink was dry. I sent the photos to 3 people. My personal attorney, my business partner, and a folder on an encrypted server I maintain for active cases. Then I stood up, thanked Constance for her time, and walked back to the NICU to sit beside my daughters. In my career, I have learned that the most dangerous moment in any financial crime is not the signing. It is the moment the perpetrator believes the transaction is already complete. That is when the evidence is fullest. That is when the paper trail is still warm. I sat beside Nora's incubator and I held her hand through the port, 4 fingers the size of paper clips, wrapped around my index finger, and I did not cry. I held the weight of what had just happened and I let it settle into me like ballast. And then I began to think in numbers. 2 weeks after the girls came home, Daniel and I received a letter from the office of Constance's estate attorney. I read it in the kitchen at 6 a.m. while the twins slept and Daniel was in the shower. It was the kind of letter designed to look like a courtesy and function as a threat. A formal notification that Constance was reviewing her estate planning documents and wished to meet with us at our earliest convenience. I called my attorney before Daniel finished his coffee. What I had not told Daniel, what I had been quietly investigating for 11 days, was that Constance's fortune was not structured the way she had led her family to believe. I had started, as I always start, with the wire transfer. $22 million does not materialize from a personal account without a record. The shell company she'd routed it through, a holding entity registered in the Caymans under a name that was almost but not quite random, had a corporate filing history I was able to access through a contact at the International Fiduciary Records Office. That filing history led me to 3 additional holding entities. Those entities collectively held interests in 4 real estate trusts and 2 private equity funds. None of those assets were disclosed in the prenuptial agreement she had required Daniel to sign before our wedding. An agreement, I should note, that she had drafted. An agreement that included, in Section 14, subsection C, a clause that protected Daniel's inheritance from any marital claim, but that defined inheritance by reference to a disclosed asset schedule. A schedule that was now, provably, incomplete. I am a forensic accountant. I follow the money until I find where it was hidden, and then I follow the hiding. I also found in the corporate records of Constance's primary holding company a promissory note dated 11 years prior. A loan made to her late husband's brother, a man named Gerald who had since died, in the amount of $4 million. Gerald had died intestate. His estate had been administratively closed without the note being called. It was legally still collectible against his surviving spouse, whose children included 2 adult daughters who had inherited Gerald's estate without knowing this debt existed. Constance had never filed to collect the note. She had kept it. I understood why. It was leverage held in reserve, the financial equivalent of a file in a drawer. She collected these instruments the way other people collect insurance policies against a rainy day. I sat with that note for a long time. I read it 3 times, then once more. I called my attorney and said, "I need to understand the full scope of what we're working with." She said, "Give me 48 hours. 48 hours later, I understood the full picture. If you have ever watched someone move through a room full of people they have deceived, perfectly composed because they believe the deception is complete, you already know what the next few weeks looked like. Stay with me. The request to meet came 10 days later. Constance called Daniel and said she wanted a family dinner. She used that phrase 3 times in the same sentence. She said she wanted to discuss the future, which in Constance's language was not an invitation. It was a summons. In the 2 weeks between our conversation in the consultation room and that dinner, Constance had done several things. She had instructed her attorneys to formalize the custody proposal into an actual legal filing, not yet submitted to any court, but drafted, notarized, and ready. She had also, I would later learn, transferred the balance of the original $22 million back out of the escrow when I did not move to access it. She thought she was being strategic. She was being documented. She had also, during this period, spoken to her inner circle, 2 friends who functioned as her chorus, her confirmation, her audience, about the arrangement. One of them had apparently said, with what I imagine was genuine bewilderment, "But doesn't she work with numbers?" And Constance had said reportedly, "She works for other people. She does what she's told." That reached me through a friend of a friend. It is not how I prefer to receive intelligence, but I do not discard intelligence because of how it traveled. At dinner, before the autres arrived, Constance said that she had consulted with her attorney, and that she wanted to clarify the terms of the family's arrangement going forward. She looked at Daniel when she said it. She did not look at me. This was intentional. She had always conducted her negotiations through Daniel, using him as the conduit, the softener, the man who would eventually translate her demands into something I might accept because I loved him. What she did not know, what Daniel did not know yet because I had not told him everything, only that I was handling it, was that I had spent 3 weeks building a complete financial map of her holdings. Every account, every entity, every note, deed, trust instrument, and beneficial interest that bore her name or the name of any entity she controlled. The map was 17 pages long. Daniel said quietly, "Mom, I think we should hear what Nadia has to say." He used my name like an offering. He always did. I said, "Thank you. I'd appreciate a moment." I reached into the bag I had brought to dinner, a plain canvas tote, the kind I carried to the office, and I set a folder on the table. I want to describe what I laid out item by item because the specifics are the point. The specifics are always the point. The first page I placed on the table was a copy of the custody proposal Constance had slid to me in the hospital consultation room. I had printed it in full, with the wire transfer confirmation stapled to the back. I said, "This was presented to me on March 18th, 4 days after our daughters were born, in a family consultation room at Mercy General, while I was still on hospital-grade pain management. I want everyone at this table to see it." Constance said, "That was a private conversation." I said, The document has a notary stamp and a date. Private conversations don't require notarization. The second page was the corporate registration for the shell company that had sent the wire. I placed it beside the custody proposal and said, "This is the entity the 22 million originated from. It was registered in 2019, 3 years before the girls were born. I want to note that this entity does not appear in the asset schedule attached to Daniel's prenuptial agreement." Constance said, "That's a business holding. It's not marital property." I said, "You're right. It isn't. But it is an undisclosed asset in a document you prepared." I placed the prenuptial agreement's asset schedule on the table, next to the corporate filing. Section 14, subsection C defines Daniel's inheritance by reference to this schedule. The schedule is incomplete. Her attorney, who had been sitting 2 seats down in what I suspect was a planned show of force, leaned forward and said, "This is not the appropriate venue." I said, "I'm not filing anything tonight. I'm having dinner." I said it the way you say it when you mean the opposite of its surface. The third item was the promissory note. Gerald's debt. For $1 million unpaid, collectible against his surviving estate. I placed it in front of Constance and said, "Gerald's wife, your sister-in-law, doesn't know this exists. His daughters don't know this exists. You've held this note for 11 years without calling it. I'd like to understand why." The room had changed temperature. I could feel it the way you feel a pressure drop before weather. Constance said very quietly, "That is none of your business." I said, "It became my business when you put a dollar amount on my children." She looked at me then. For the first time that evening she actually looked at me. And I could see the thing she had mistaken for compliance rearranging itself behind my eyes, and I could see the moment she understood that she had miscalculated. Not the money, not the custody, the person across the table. Daniel said, "Mom, just that. Just her name." But he said it the way you say something when you finally understand a sentence you've been reading wrong for years. Her friend, the one who had been sitting to her left, who had arrived with Constance as moral support, or perhaps audience, said, "Maybe we should all take a breath." I said, "I'm not holding mine." I took out the last item. It was not a document. It was a photograph printed on standard paper, dated in the lower right corner. It was a photo from Daniel's childhood birthday party, his 8th birthday, by the banner in the background. He was blowing out candles. Constance was standing behind him, not watching the candles. She was watching the door. Her phone was in her hand. The timestamp in the original digital file's metadata, which I had accessed through Daniel's family photo archive, showed she had received and sent 2 messages during the 60 seconds that photo was taken. I had printed those messages on the back. They were communications with her attorney about a trust restructuring that had, that same week, quietly removed Daniel as the primary beneficiary and replaced him with the charitable foundation she controlled. His 8th birthday. He had been 8 years old. I placed the photo on the table face up. I did not say anything about it. I let it be. Her friend, the one with a conscience that was apparently not entirely decorative, looked at the photo for a long moment and then looked down at her hands and did not look up again for a while. She did not speak. She did not earn absolution by going quiet at the 11th hour. But I noted it. Constance said, "You don't know what you're doing." I said, "I know exactly what I'm doing. I count things for a living. I've been counting yours." I closed the folder. I put it back in the canvas tote. I stood up, picked up my bag and looked at Daniel. He was already standing. I said to Constance one final sentence before I walked out. "The note comes due when I file. Think carefully about what you want the balance sheet to say." What happened after that dinner took 14 months and required 4 separate attorneys, 2 forensic reviews, and 1 deposition that lasted 9 hours. Here is what the balance sheet said in the end in plain numbers. The undisclosed assets in Constance's holding entities were subject to a claim under the prenuptial agreement's asset schedule clause. Her attorneys argued the clause was ambiguous. The judge did not agree. The settlement required full financial disclosure and a restructuring of Daniel's beneficial interest in the primary family trust, restoring him as a direct beneficiary rather than a contingent one. The value of that restoration: approximately $9 million in vested trust interests. The promissory note from Gerald's estate. Constance's attorneys, facing discovery, agreed to forgive the note permanently and in writing. Gerald's daughters received that notification through their own attorney. One of them sent me a card. I still have it in a drawer. The custody proposal, the original document, the $22 million, the shell company, was referred to a family law specialist who filed a formal complaint with the state bar against the attorney who had drafted it. That attorney's license is currently under review. The $22 million never moved again. The escrow expired. The money returned to its origin. Constance retained her fortune. I want to be clear about that. I did not take her money. I did not attempt to. What I did was ensure that every dollar she held was visible, documented, and accurately placed. I balanced her books. That is all. A forensic accountant does not steal. She counts. And when the counting is done, she presents the findings. Daniel's therapist told him months later that the photograph had been the thing he kept returning to. Not the money. Not the documents. The photograph of himself at 8 years old, blowing out candles, while his mother arranged his inheritance without his knowledge. He said, "I always knew, but I never had the receipt." I told him, "Receipts are just the truth with a timestamp." Constance's friend, the one who looked down at her hands during the photo, eventually reached out to Daniel privately, not to apologize, not quite, but to say she had not known the full picture and that she was sorry for the role she played as audience. Daniel thanked her politely. It was not enough. It was also not nothing. She lives with what she knows now. That is a consequence too, just a quieter one. The girls, Nora and June, now 14 months old, pulling themselves up on furniture and falling and pulling themselves up again with total disregard for the inconvenience. No, none of this. Someday, when they are old enough to understand balance sheets, I will show them the folder. Not as a lesson in revenge. As a lesson in what it means to know your own value and to refuse any offer that pays less. The photograph lives in a frame on my desk at the office. Not Constance's photograph. A different one. It is a photo taken in the NICU, the night Nora and June were 3 days old. Daniel is holding one in each arm. He is not looking at the camera. He is looking at them. His face has an expression I have never been able to name professionally. I don't have a ledger entry for it. I leave it uncategorized. Some things don't need to balance. With the funds from the trust restoration, Daniel and I established 2 education accounts, one for each girl, fully funded irrevocably, with independent trustees and a clause specifying that the accounts are not subject to contest, claim, or condition by any family member. Not by us either. They belong to the girls. Unconditionally. Without terms. That is the only kind of gift that means what it says. There is a letter in the girls' safe deposit box. I wrote it the week they came home from the NICU. It is not a dramatic letter. It does not use words like legacy or strength, or any of the words people put on plaques. It says simply, "You were worth more than any number anyone will ever put on you. Anyone who tells you otherwise is asking you to pay a debt you did not incur. Don't sign." Constance is alive. She is 71. She has not met the girls. That was not a decision I made. It was a condition I set. The door is not locked. But it has terms now, and the terms are mine. She has not accepted them yet. Perhaps she will. Perhaps she won't. I am comfortable with either outcome. I have very good files. Some people in my life, people who know pieces of this story, have called what I did revenge. I understand why. But that is not the word I use. Revenge is when you take more than what you're owed. What I did was simply present and accurate accounting. Every figure documented. Every instrument verified. Every balance restored to its correct position. I did not take from Constance. I stopped letting her take from us. There is a difference. It lives in the paperwork. If this story reminded you that knowing your own value is not arrogance, it is the prerequisite for every negotiation you will ever be in, then take that with you. If you have spent years absorbing costs that were never yours to carry, that is worth looking at. Not with anger. With a spreadsheet, maybe. Quiet people keep the receipts. And the receipts in the end are the story. Drop a comment if you know the weight of a folder placed quietly on a dinner table. Subscribe if you believe that some kinds of calm are the most dangerous thing in the room. I'll see you in the next one.